I want you to stop whatever you are doing right now and listen carefully, because what I am about to tell you in the next 30 minutes affects every American over the age of 65 who owns a home, has a retirement account, or has any assets whatsoever that they have spent a lifetime building. There is a Medicaid rule change that went into effect in 2026 that the federal government did not send you a letter about. Your Medicare card did not come with an explanation. Your financial advisor probably did not mention it at your last meeting. Your doctor certainly did not bring it up during your annual physical. And the Social Security Administration, which sends you a cost of living adjustment notice every January, said absolutely nothing about this rule change that could cost you and your family everything you have built if you do not understand it and act on it before you need long-term care. I am not saying this to frighten you. I am saying this because Retire Right America exists specifically to tell you the truth about how the systems that govern your retirement and your health care actually work in 2026, not how you assume they work based on information that may be years or decades out of date. The rule I am about to describe affects the single largest financial risk facing Americans over 65 today. Not the stock market, not inflation, not Social Security solvency. Long-term care and the Medicaid system that pays for it when private resources are exhausted. And the 2026 changes to how Medicaid evaluates, counts, and recovers assets from seniors and their families are the most significant updates to this system in over a decade. If you are over 65 and you do not understand what changed, you are operating under assumptions that could cost your family hundreds of thousands of dollars. Let me give you a woman named Helen. Helen is 71 years old. She lives in a ranch house in Clearwater, Florida, that she has owned since 1989. Her husband, Frank, passed away 4 years ago. Helen lives alone. She manages her own finances. She has a traditional IRA worth approximately $280,000. She has about $65,000 in a savings account at her credit union. She has Social Security of $1,800 per month, and she owns her home, which is worth approximately $290,000 with no mortgage. Helen is in reasonably good health today. She has some arthritis. Her blood pressure requires medication, but she drives herself to appointments, manages her own household, and considers herself independent. Helen has a daughter named Patricia, who lives 40 minutes away and who checks in regularly. Patricia has been telling Helen for 2 years that she should talk to an elder law attorney about her finances. Helen has been putting it off because she feels fine, because the legal fees feel unnecessary when nothing is wrong, and because she has a vague sense that Medicare will take care of her if she ever needs serious care. Helen is operating on 3 assumptions that were partially accurate 5 years ago and that are dangerously incorrect in 2026. The first assumption is that Medicare covers nursing home care if she needs it. The second assumption is that her home is protected from the government as long as she is alive. The third assumption is that she has time to plan later, when and if a health crisis actually arrives. All 3 of these assumptions are wrong, and the 2026 Medicaid rule changes have made them more wrong, more expensive, and more urgent to correct than at any point in the last decade. Let me walk through exactly what changed and what it means for Helen and for every senior watching this video right now. Before I get to the 2026 specific changes, I need to make sure you understand the foundation of how Medicaid long-term care actually works, because if you do not understand the baseline, the changes will not make complete sense. Medicare, the federal health insurance program that most Americans over 65 are enrolled in, does not cover long-term custodial care in a nursing home or memory care facility. Medicare covers short-term skilled nursing care after a qualifying hospital stay, up to 100 days under specific conditions, and then Medicare stops. After Medicare stops, you pay privately. Private pay rates at skilled nursing and memory care facilities in Florida in 2026 average between $9,000 and $13,000 per month, depending on location and level of care. When your private resources are spent down to near zero, you may apply for Medicaid, which is the joint federal and state program that actually pays for long-term custodial care. To qualify for Medicaid long-term care, you must have countable assets below a very low threshold. For a single individual like Helen, the countable asset limit is approximately $2,000 in most states. $2,000, after a lifetime of saving. Everything above that limit must be spent on care before Medicaid will pay. The Medicaid system looks at your assets through what is called a lookback period. Any transfer of assets for less than fair market value made within a certain number of months before your Medicaid application gets penalized. This look-back period is where the most significant 2026 changes have occurred, and understanding those changes is critical for every senior who has not yet completed their Medicaid planning. The first major 2026 change that Helen does not know about is the expansion of the Medicaid look-back period in several states, and the federal guidance that is pushing remaining states toward a longer look-back window. The standard Medicaid look-back period has historically been 60 months. 5 years, meaning the state reviews any asset transfer made within 60 months of the Medicaid application. If you transferred your house to your children 4 years before applying for Medicaid, the state finds that transfer and calculates a penalty period during which Medicaid will not pay for your care. In 2026, several states have implemented or are implementing extended look-back periods for specific types of asset transfers, particularly transfers involving real estate, retirement accounts, and certain trust structures. The Federal Centers for Medicare and Medicaid Services has issued guidance that encourages states to enhance their look-back review processes and to apply more rigorous scrutiny to transactions that were previously reviewed less carefully. The practical effect for Helen in Florida is that the 5-year window she thought she had to plan is being scrutinized more carefully than it was 3 years ago, and the types of transactions that trigger penalties are being defined more broadly than before. A financial gift to Patricia that Helen made 18 months ago as a birthday present, an amount that felt too small to matter in the context of estate planning, is now potentially reviewable as a disqualifying transfer if Helen applies for Medicaid within the look-back period. The threshold below which gives her automatically exempted from Medicaid penalty calculations has not kept pace with inflation and remains extremely low in most states, meaning many routine family financial transactions that seniors consider minor gifts or ordinary family support payments may be subject to Medicaid penalty analysis. The second major 2026 change involves the treatment of retirement accounts, specifically traditional IRAs, in Medicaid eligibility determinations. This is the change that is catching the most seniors off guard because the rules around retirement account treatment have varied significantly by state and have been evolving in ways that create enormous confusion. Historically, the treatment of an applicant's IRA for Medicaid purposes depended on whether the account was in payout status, meaning whether the account owner was taking required minimum distributions or voluntary distributions. In states that followed the payout status rule, an IRA that was in payout status was considered an available resource and counted against the Medicaid asset limit, while an IRA that was not in payout status was potentially exempt or treated differently. In 2026, federal guidance and state rule changes have moved toward a more consistent national standard that treats traditional IRAs and 401k accounts as countable resources for Medicaid eligibility purposes once the account owner has reached the age at which required minimum distributions must begin, which is currently 73 under federal law. For Helen, who is 71 and has not yet reached her required minimum distribution age, her IRA may currently be treated more favorably under her state's rules than it will be in 2 years when she turns 73. This 2-year window before her RMD age is potentially her most important planning window for repositioning the IRA into a more protected structure. Once she turns 73 and RMDs become mandatory, the IRA becomes more clearly countable under the evolving national standard, and her planning options narrow significantly. The third major 2026 change is the expansion of Medicaid estate recovery programs and the aggressiveness with which states are pursuing recovery claims against deceased beneficiaries' estates. Federal law requires every state to have a Medicaid estate recovery program that seeks reimbursement for Medicaid expenditures from the estates of deceased beneficiaries. What has changed in 2026 is the scope of assets that many states are pursuing in recovery claims and the legal mechanisms being used to reach assets that were previously considered protected. Historically, most states limited their estate recovery claims to probate assets, meaning assets that passed through the formal probate court process. Assets that passed outside of probate through beneficiary designations, joint tenancy, or revocable living trusts were in many states beyond the reach of Medicaid recovery. In 2026, a growing number of states are expanding their recovery claims to reach non-probate assets using expanded estate definitions that include assets that were under the Medicaid beneficiary's control or that passed by operation of law at death. For Helen in Florida, this means that the assumption that her home is protected from Medicaid recovery because it will pass to Patricia through a joint tenancy or beneficiary deed rather than through probate may not be as reliable as it was 3 years ago. Florida is among the states that have been reviewing their estate recovery procedures, And while Florida has historically had more beneficiary protections than many states, the direction of change nationally is toward broader recovery authority, not narrower. Helen cannot assume that the strategies that would have protected her home 5 years ago will be equally effective under the rules that apply in 2026 and beyond. The fourth major 2026 change involves the treatment of annuities and promissory notes as Medicaid planning tools. Medicaid-compliant annuities have historically been used as a strategy to convert excess countable assets into an exempt income stream for the community spouse, allowing the applicant spouse to qualify for Medicaid more quickly without spending all assets on nursing home care. The specific requirements for a Medicaid-compliant annuity, including that it must be irrevocable, non-assignable, actuarially sound, and name the state as remainder beneficiary, have been tightened in 2026 in ways that make it harder to use annuities as a last-minute planning tool during a Medicaid crisis. States are applying more rigorous actuarial soundness standards to annuities purchased near the time of Medicaid application, scrutinizing the insurance carriers used for these products more carefully, and in some cases challenging annuity purchases that meet the technical requirements but that are viewed as inconsistent with the intent of the Medicaid planning rules. The practical implication is that the window for using annuity-based Medicaid planning strategies is narrowing, and the strategies must be executed with more precision and with more lead time than they required in previous years. Now let me bring this back to Helen specifically, because I want to show you what Helen's situation looks like through the lens of the 2026 changes and what her specific planning priorities should be given her age, her asset profile, and her health status. Helen is 71. She is 2 years away from her RMD age. Her IRA of $280,000 is currently in a planning window that will narrow significantly when she turns 73. Her home is worth $290,000 and is subject to potential Medicaid estate recovery, depending on how it is titled and how her state's recovery rules evolve. Her $65,000 savings account is fully countable and would need to be addressed in any Medicaid planning strategy. Helen's most urgent planning priority is establishing a relationship with an elder law attorney who specializes in Medicaid planning in Florida specifically, not a general practice attorney, not a financial advisor, and not a CPA who does tax work. An elder law attorney who does Medicaid planning daily in Florida will know the current state of Florida's Medicaid rules as they stand in 2026, will know how Florida's estate recovery program is being applied in current cases, and will know which planning tools are currently working in Florida courts and which are being challenged successfully by the state. Helen's second planning priority is addressing the home. A Florida Ladybird deed, which is an enhanced life estate deed that Florida recognizes, allows Helen to transfer the home to Patricia while retaining complete control during her lifetime, including the right to sell, mortgage, or revoke the transfer, and without triggering the Medicaid lookback in Florida's current interpretation of the rules. The Ladybird deed accomplishes 3 things simultaneously. It removes the home from Medicaid estate recovery risk after the 5-year lookback period from the date of execution. It preserves Helen's step-up in basis benefit for Patricia, meaning Patricia inherits the home with a fresh cost basis at the date of Helen's death and can sell it with no capital gains tax on the appreciation. And it avoids probate entirely, transferring the home to Patricia automatically at Helen's death without court involvement. The Ladybird deed costs approximately $300 to $500 in attorney fees and recording costs in Florida. The protection it provides against a potential $290,000 estate recovery claim is one of the highest return legal investments available to a Florida senior homeowner. Helen's third planning priority is beginning a Roth conversion strategy on her IRA before she turns 73 and the account becomes more clearly countable under the evolving Medicaid rules. Helen is currently in the 12% federal tax bracket as a single filer. She can convert approximately $30,000 to $40,000 per year from her traditional IRA to Roth while staying in the 12% bracket, below the threshold that would trigger a significant IRMAA surcharge, and below the level that would meaningfully increase her Social Security taxation. Over 2 years before her RMD age, Helen could convert $60,000 to $80,000 to Roth, reducing the traditional IRA balance from $280,000 to approximately $200,000 to $220,000. The Roth IRA has no required minimum distributions and is treated differently than a traditional IRA in many states' Medicaid analyses because there is no mandatory distribution requirement that makes the account immediately accessible. The conversion does not eliminate the Medicaid exposure on the Roth IRA, but it changes the analysis and may provide more planning flexibility in future years, depending on how Florida's rules continue to evolve. Helen's fourth planning priority is addressing the savings account through a combination of permitted expenditures and strategic positioning that reduces the countable asset balance without triggering the look-back period. Paying for an irrevocable prepaid funeral and burial plan for herself up to Florida's permitted limit. Making any needed home improvements or accessibility modifications to her home, and ensuring her liquid emergency reserve is appropriately sized relative to her income and expenses are all strategies that can reduce the countable asset number while converting cash into assets that the Medicaid system treats more favorably. I want to be very direct with Helen about the timing issue because it is the point that matters most and that is most consistently ignored until it is too late. Helen feels fine today. Helen plans to address this later when she needs to. The 5-year look-back means that the planning Helen does today does not fully protect her until 5 years from today. If Helen establishes the Ladybird deed today, the home is outside the look-back window in 2031. If Helen waits 2 years because she feels fine and nothing urgent is happening, the home is not outside the look-back window until 2033. The health event that requires nursing home placement does not announce itself in advance. It does not give Helen time to execute 5 years of planning before the Medicaid application clock starts. A stroke, a fall, a rapidly progressing memory condition, any of these events can transform a healthy, independent senior into a nursing home resident within weeks. At that point, the planning that could have been done at minimal cost and minimal inconvenience becomes either impossible, enormously expensive, or subject to look-back penalties that negate its effectiveness. The families who end up in the worst situations are not the ones who did bad planning. They are the ones who did no planning because nothing felt urgent until the moment everything became urgent simultaneously. Helen has a 2-year window before her RMD age narrows her IRA planning options. She has right now as the starting point for the 5-year look-back clock on her home transfer. She has her current health, which allows her to sign legal documents, make informed decisions, and act with full capacity. Every one of those advantages disappears if she waits for a crisis to motivate the planning. This is why Retire Right America covers Medicaid planning with the level of urgency that we do. Not because we want to frighten seniors who are enjoying their retirement and managing their health thoughtfully, but because the financial system and the healthcare system and the legal system are all operating on timelines and with rules that most seniors do not know about, that are changing in 2026 in ways that narrow the planning window further, and that will determine whether the assets Helen spent 40 years building pass to Patricia or pass to the state of Florida through a state recovery after years of nursing home care. Go to the comment section right now and tell me your state, your approximate age, and whether you own your home free and clear. Tell me whether you have a traditional IRA and whether your RMDs have started yet. Tell me whether you have ever met with an elder law attorney specifically about Medicaid planning, or whether your estate planning consists only of a will that you signed years ago. Drop your situation and we analyze it together. Like this video if Helen's story showed you something about your own situation that you had not thought about clearly before today. Subscribe to Retire Right America and hit the notification bell so every update we produce about Medicaid rule changes reaches you before the changes affect your planning window. Share this with a parent, a sibling, or a friend over 65 who owns a home and has a retirement account and has not yet spoken with an elder law attorney about Medicaid planning. Because the 2026 changes are real, the window is narrowing, and the time to act is before the crisis, not after. This is Retire Right America. Stay informed, stay protected, and plan before the rule changes plan for you.